They say the law protects everyone equally. What they don't tell you is that the law only works for the person who reads the document all the way to the bottom. The pen was already on the table when I arrived. A ballpoint, nothing special, the kind kept in a drawer for signing things without thinking. The study smelled the way my father's study always smelled. Old paper and cedar, and particular dry warmth of a room where serious things had been decided for 40 years. And I already knew, the moment I saw that clause, exactly what I was going to find. Welcome back to Dad's True Revenge, where silence is never surrender. If you've ever built something quietly while others claimed it, this story is for you. Drop a comment and be sure to subscribe. You're going to love it here. My name is Leonard Burke. I am 62 years old, and I have practiced family law in Savannah, Georgia, for 31 years. My office is at Burke and Harmon on Drayton Street, a 2-story brick building 3 blocks from Forsyth Park, with a brass nameplate on the door that I paid to have installed in 1993 and have never seen a reason to change. I have handled estate disputes, property transfers, probate filings, and family trust administrations for clients across Chatham County for 3 decades. I know how documents work. I know where they hide what they mean. My father was Leonard Burke Sr. He was a man who built things with his hands before he built things with capital. He started with a hardware store on Broughton Street in 1971 and grew it, over 20 years, into a small property holding company, 4 residential parcels and 1 commercial lot in the Ardsley Park and Starland neighborhoods. He was not a wealthy man in the way the word is used carelessly. He was a careful man. He paid cash when he could. He kept paper records. He trusted the people he had decided to trust, and he trusted them completely, which was both his greatest quality and the one that made what happened possible. My mother died in 1997. After that, my father handled his affairs with the kind of stubborn independence that men of his generation treated as a form of dignity. But after his first cardiac event in March 2016, at a quarterly appointment at the Savannah Heart Institute, his cardiologist told him he needed someone to manage the legal complexity of the property company. He called me that same evening at 7:33 p.m. and asked if I would take it on. I told him I would. From 2016 onward, I handled every legal matter he had. I filed his property company's LLC renewals with the Georgia Secretary of State for 11 consecutive years, without billing a single hour. In 2011, before the formal arrangement, I had already cleared a title dispute on the Habersham Street parcel, 4 months of research, correspondence, and 2 court appearances, all unpaid, because he was my father and the property was his retirement. In 2009, when he first mentioned wanting a will, I drafted it myself over 2 evenings at my desk on Drayton Street. It was a clean document. 3 children, equal shares. The property company held in a trust administered by the estate until final distribution. He signed it on March 8, 2009 at my office at 3:14 in the afternoon. I filed a copy with Harold Finch, his personal accountant at Finch Financial Services on Montgomery Street, who had handled my father's taxes since 1988. I kept the original in my own files. My throat tightened every time I opened that file after 2016. Not from grief, not exactly. From the specific weight of knowing what the document meant and knowing that my father trusted me with it completely. Claire died in August 2018. Pancreatic cancer, diagnosed in February, gone by August. She was 58 years old. She had been my wife for 29 years, and she had sat across from me at the kitchen table at 318 Habersham Street on 11,000 mornings, and the silence of that kitchen after August 14th was a different kind of silence than any I had encountered in a courtroom. I prepared and filed her estate without billing a single hour to the family. Not because anyone asked me to, but because it was the last thing I could do that had her name on it. My hands went still every time I opened that file. For months afterward, my father knew what losing Claire meant. He called every Sunday evening at 6 p.m. for 2 years after she died, without missing a week. He called to talk about nothing important. The garden, the hardware store building he'd sold in 2004, a neighbor's dog. He called because he understood that presence was a thing, that the content of the call was not the point. I drove him to 41 quarterly cardiologist appointments between 2016 and the spring of 2022 every Tuesday and Thursday on the schedule, and on the drive home we sometimes talked and sometimes did not, and both with the right answer. He died on November 3rd, a Tuesday, at 4:47 in the morning from a cardiac event in his sleep. He was 81 years old. I was at his house on East Victory Drive by 5:22 a.m. My brother Philip is 57. He lives in Atlanta, where he runs a commercial real estate consulting firm that has been, from what I could observe through the years, persistently undercapitalized. Philip is a man who moves with the confidence of someone who has always expected things to resolve in his favor, and who has, more often than not, found a mechanism by which they do. He and my father were close in the way that fathers and sons are sometimes close when the son is careful to be available at the moments that matter without being present for the ones that require labor. My sister Diane is 54. She lives in Brunswick, 30 minutes south, and has relied on the comfort of family consensus in most decisions I have observed her make. She is not a cruel person. She is a person who follows the direction of whoever in the room has decided where things are going. The will reading was scheduled for November 14th at the offices of Savannah State Attorney named Robert Talmadge, whom I had not previously worked with and whom I recognized immediately as a man selected by someone who wanted a different attorney at the table than me. I noted this but said nothing. I arrived at Robert Talmadge's office at 9:31 a.m. Philip and Diane were already there. Philip was standing near the window with a coffee. Diane was seated. Neither of them had called me in 11 days since our father died, except for a single logistical text about the funeral home. My chest ached at that detail, in a way I did not examine directly. Robert Talmadge came in at 9:44 a.m. He set a document on the table, 12 pages, tabs, spiral-bound, the kind of professional presentation that indicates a document assembled with care by someone billing a high rate. He explained that our father had updated his will in October, 3 weeks before his death. There had been some adjustments, he said, to the distribution structure. He slid the document across the table. Then Philip reached into his jacket pocket and set a ballpoint pen on the table in front of me. "Len," he said, "we thought it would be cleanest if you signed as witness, since you're the attorney in the family. Keeps things professional." I looked at the pen. "Not as heir," Diane added, "just as witness. It's cleaner that way. It's what Dad would have wanted, keeping in the family." I said nothing. The room was very still. Talmadge was looking at his folder. Philip was looking at me with the particular steadiness of a man who has rehearsed this moment. I picked up the document. I did not pick up the pen. A will is not what a man leaves behind. It is the last sentence he ever speaks. My father spoke in plain language, in short sentences. In ink, he pressed hard enough to leave an impression on the page beneath. The document in my hands was 12 pages of structured language that did not sound like him at any point. I read every line. My face held. My breath stayed even. I turned to page 7, where the distribution clause had been restructured, and I read the clause that had been inserted. The clause redirected the property company, all 4 residential parcels and the commercial lot, into a single beneficiary trust administered by Philip Burke, with Diane Burke Osgood named as secondary. My name appeared once in the document, in the witness signature line at the bottom of page 12. My stomach dropped, slowly, completely, the way it does when you see a structural failure in a document you know should have held. I said nothing. "Len," Philip said, "it's straightforward. Dad made his wishes clear. We just need the witness signature to finalize." I said nothing. "We thought this would be easier for you," Diane said, "given everything with Claire. You've had a hard few years. This way you don't have to manage the property. It's a kindness, really." Something in my chest went cold. I kept my face neutral. I set the document on the table with the same care I would use setting down any document that I intended to file. "When was this drafted?" I said. Talmadge said October 9th. "Who engaged you?" I said. There was a pause. Philip contacted my office. Talmadge said. I nodded once. I folded my hands on the table. I looked at the revised distribution clause for a long moment. The clause had been inserted at Section 4B, between 2 paragraphs of standard boilerplate, in a font that matched the surrounding text, but at a point size that was, if you knew what you were looking at, zero point 0.3 points smaller than the rest of the document. Someone had been careful. Not careful enough. I'll need to review this before I sign anything, I said. Philip's jaw tightened. Len, it's a straightforward. I understand, I said. I did not mean I agreed. I took the document. I left Talmadge's office at 11:03 a.m. I walked to my car on Drayton Street, and I sat in it for 6 minutes with the document on the passenger seat and the November light coming flat through the windshield. I thought about my father's voice on the phone at 7:33 p.m. in March 2016, asking me to take it on. I thought about the original will, the clean document I had drafted myself on 2 evenings in 2009, with my father's signature pressed hard enough to indent the page. I thought about where that document was. It was in a fireproof lockbox in my father's study on East Victory Drive. I had been the one who suggested he keep it there. I drove to the house at 12:47 p.m. I had a key. I had always had a key. My father had given it to me in 2016 and never asked for it back. The study was the second room on the left past the kitchen. It smelled the same as it always had. Old paper and cedar and the particular warmth of a room that held 40 years of decisions. The lockbox was on the second shelf of the bookcase, behind the row of hardware industry directories my father had kept since 1975. I opened it at 2:14 p.m. The original will was there. 14 pages, handwritten annotations in the margins of my father's hand, the indented ink, the short sentences, the plain language, dated March 8, 2009. Signed Leonard Burke, Sr., at the bottom of page 14. Witnessed by Harold Finch and my former paralegal at Burke and Harmon, a woman named Ruth Graves who had retired in 2015. My shoulders dropped, not in defeat, in the particular release of a man who has found exactly what he went looking for. I call Harold Finch at 4:38 p.m. Harold was 71, a spare, methodical man who had kept my father's financial records since the year I graduated law school. He confirmed he had a copy of the 2009 will in his files. He had kept it, he said, because your father asked him to, and he had not been contacted by anyone since the death about any estate matters. He said this carefully, the way careful people signal that they are aware something is wrong. I told him I would need a certified copy. He said he would have it ready the following morning. I spent the evening at my desk on Drayton Street. I pulled every property record associated with the Burke Family Trust, the 4 residential parcels, the commercial lot, the LLC filings going back to 2013. I cross-referenced the October 9th document against the original 2009 will. The inserted clause in Section 4B had no counterpart in any prior document. There was no letter of instruction, no codicil file with any county recorder, no notation in my father's accountant records indicating a change of intent. The October 9th document represented a single-session revision prepared by an attorney engaged by one of the 3 beneficiaries, 11 days before the testator's death. My father had been hospitalized for 5 days in October, beginning the 4th. He was discharged on the 9th. I sat with that fact for a long time. On December 1st at 8:22 a.m., I filed the original 2009 will with Margaret Soule, probate court clerk at Chatham County Superior Court, along with a formal objection to the October 9th document on grounds of undue influence and procedural irregularity. Margaret Soule accepted the filing, stamped the receipt, and issued a docket number. The probate hearing was scheduled for December 2nd at 10 a.m. Philip called at 9:14 p.m. on December 1st. I did not answer. He called again at 9:31 p.m. I did not answer. At 10:04 p.m., he sent a text that said, "Len, we need to talk before tomorrow. This is going to get complicated for everyone." I read it. I set the phone face down on the kitchen table at 318 Habersham Street, and I looked at the November dark outside the window, and I let the sentence settle into the room where it belonged. The hearing began at 10:11 a.m. on December 2nd before Dale Whitfield, probate judge, Chatham County Superior Court. Talmadge appeared for Philip. I appeared for myself, which is a thing that attorneys are advised against, and which I had decided was the only appropriate choice. Diane sat in the gallery. She did not look at me when I walked in. Talmadge presented the October 9th document. He characterized the revision as a straightforward expression of my father's updated estate planning wishes. I presented the 2009 original, Harold Finch's certified copy, and a 12-page brief I had prepared in 4 evenings at Drayton Street documenting the timeline. The hospitalization beginning October 4th, the discharge on October 9th, the document execution on October 9th at 2:17 p.m., the same afternoon of discharge at Talmadge's office, with no prior correspondence, no prior engagement letter, no record of my father independently initiating contact. I presented Harold Finch's sworn affidavit, confirming the 2009 will's existence and custody chain. I presented the original document itself, my father's handwriting in the margins, the press-hard signature at the bottom of page 14. Judge Dale Whitfield reviewed both documents for 11 minutes in silence. Then he asked Talmadge 3 questions. Talmadge answered 2 of them directly. The third question, regarding evidence of the testator's independent initiation of the October revision, he answered in language I recognized as a language of man who does not have an answer. At 3:09 p.m., Judge Dale Whitfield entered the 2009 will into the record as a controlling instrument. He set aside the October 9th document pending a formal undue influence proceeding. He noted from the bench, in particular measured register a judge who is choosing his words with care, that the timeline of execution raised questions the court would want addressed in subsequent proceedings. Philip's face went still, not the still composure, the still of a wall absorbing an impact it was not built for. The color left his jaw first, then moved upward. His hands, which had been flat on the table, did not move. I said nothing. I kept my voice level. I gathered my documents. I placed them in the manila folder I had brought, and I closed the class with the same deliberate care I use for every filing. "The court will be in touch," Judge Whitfield said. I thanked him. I walked out. I was in my car in the courthouse parking lot on Montgomery Street. At 3:31 p.m., something in me turned over slowly. Not triumph, not relief exactly. The specific sensation of a load-bearing element returning to its correct position after being displaced. My chest ached. I sat with that. I thought about my father pressing hard with his pen in March of 2009 because he wanted the signature to mean something. It meant something. The formal undue influence proceeding was scheduled for February. Talmadge withdrew as counsel for Philip in December on the 19th. Philip retained new counsel on January 8th. Diane called me on December 22nd at 4:17 p.m., and we spoke for 44 minutes. She said she had not known about the hospitalization timing. I believed her. We have spoken twice since. The property trust was administered per the 2009 will. Equal distribution. 3 parcels in the commercial lot divided into 3 equal shares, valued at the time of distribution by a certified appraiser at $1.2 million total. Harold Finch oversaw the financial accounting. I handled the legal transfer of my own share only, billing 0 hours. Leonard Burke, 62 years old, and still at 318 Habersham Street, in the house with the Habersham Street parcel 2 doors down that my father bought in 1987, and that is mine now, because he pressed hard with his pen in 2009 and meant every word. 31 years of filings. 1 lockbox. 1 original. What would you have done? Signed that witness line and walked away, or read every word until you found what they were hoping you wouldn't? If this story reached something in you, hit that like button and subscribe for more real, raw, and family-centered stories. And as always, thank you for being a part of this sphere.